History as it happens, March 12, 2024. Historians versus Trump, revisited.
The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons.
You want us to say that self-execution doesn't mean what it generally means?
A lot hinges on the difference between, in your argument, between the term office and officer.
Because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office.
The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States.
As a politician, they can go after me with votes, but they're not going to go after me with that kind of lawsuit that takes somebody out of a race.
The Supreme Court put Donald Trump back on the ballot in Colorado, ruling unanimously that a state cannot disqualify someone running for a federal office. And a conservative majority went further, ruling that only Congress can enforce Section 3 of the 14th Amendment by passing legislation. Well, is that what the 14th Amendment says? Mark Graber says the court got it wrong. And he's next as we report History as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
Those that are responsible for the 2020 presidential election scam. It was a scam.
I just want to find 11,780 votes.
We're trying to get compliance, but this is now effectively a riot.
49 hours declaring it a riot.
They failed to attempt to obstruct the Congress. This failed insurrection only underscores how crucial the task before us is for our republic.
In many ways, what is wrong with the decision is what is wrong with the pattern of Supreme Court decisions.
During the oral arguments on February 8th, the justices of the U.S. Supreme Court and the attorneys for each side in Trump versus Anderson spent a lot of time talking about the legal concept of self-execution, whether Section 3 of the 14th Amendment is self-executing, meaning it requires no further action to disqualify someone from holding office who had violated his oath by engaging in insurrection. Well, as a historical matter, after the Civil War, the former Confederates understood they were automatically disqualified from returning to the House or Senate. Jefferson Davis knew he could not run for president of a reconstructed United States under Section 3, which explains why all these former rebels petitioned Congress for amnesty. I was really looking forward to listening to the oral arguments. I read the amicus brief submitted by a couple dozen distinguished historians on the meaning of the 14th Amendment, and the reasons why its framers sought to disqualify then and for all time insurrectionists from the seats of power. I had interviewed Sean Wilentz for this podcast. That episode was published on February 6. After reading his essay in the New York Review of Books titled The Case for Disqualification, where he cited the work of University of Maryland legal scholar Mark Graber. Well, Graber is my guest in this episode. In fact, this is the follow-up episode to that earlier one with Sean Wilentz. So yeah, I was ready for what I hoped would be a riveting discussion about important historical issues. After all, that's what I do on this podcast. The 14th Amendment was one of three foundational Reconstruction amendments, what Eric Foner calls our second founding. Well, instead I found the dialogue between justices and counsel frustrating, even mind-boggling. As when Chief Justice Roberts asked Trump attorney Jonathan Mitchell, what if an admitted insurrectionist walked into the Colorado Secretary of State's office and said, "I'm guilty, remove me from the ballot"?
Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that consistent with term limits, because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office, and then see whether Congress lifts that disability after the election. This happened frequently in the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each House would determine for itself whether to seat that elected insurrectionist, because each House is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical, the Secretary of State would be demanding, essentially, that the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
I'm not sure the historians, including some of the greatest living authorities on the Civil War and Reconstruction, agree with Mitchell's interpretation. And then there were the long exchanges over whether the office of the president was covered under Section 3, as if the framers of the 14th Amendment somehow missed that one. They didn't, of course, as anyone who reads the historians' amicus briefs would understand. And the justices hardly touched the most important issue of all, whether Donald Trump engaged in insurrection on January 6, 2021.
The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6 qualified as an insurrection, as defined by Section 3, and I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an insurrection? What is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so
riot
the point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used in Section 3.
Thank you.
Thanks.
Thank you, counsel.
In an op-ed in The Guardian, the aforementioned constitutional scholar Mark Graber says Trump, his lawyers, and his supporters respond to charges that Trump is a traitor with numerous assertions that have nothing to do with whether Trump incited and participated in the January 6 insurrection. They claim that Section 3 exempts treasonous former presidents or permits traitors to be elected president of the United States. They insist, Graber says, that traitors can be disqualified under the 14th Amendment only if Congress authorizes the disqualification. They claim that Section 3 disqualifies only persons who committed treason during the Civil War and does not disqualify persons who lead violent secession movements now. Graber goes on to say the Supreme Court in turn invented a rule that congressional legislation under Section 5 of the 14th Amendment is necessary for federal officials to be disqualified, a rule unknown to the text of Section 3 or the persons who framed Section 3. Mississippi in 1868 under this rule could not disqualify Robert E. Lee or Jefferson Davis from the presidential ballot, writes Mark Graber. Sean Wilentz also penned a response to the SCOTUS decision in the New York Review of Books. I will embed links to all these essays as well as the Supreme Court opinions in my weekly newsletter. You can sign up at historyasithappens.com. Remember here, the three liberal justices agreed with the conservative majority in this unanimous ruling that a single state cannot disqualify a presidential candidate, but they chided the majority for inventing the rule that only Congress has the authority to act here by passing a law to disqualify someone. Mark Graber is the author of Punish Treason, Reward Loyalty, a new book delving into the origins of the 14th Amendment and its chief purpose, the author writes, of preventing rebel rule after so many Americans had died crushing a rebellion. Mark Graber, hello.
Thank you for having me.
Before we dive into the SCOTUS opinion, the Supreme Court opinion that saved Donald Trump, we'll put it that way, how would you describe your approach to constitutional scholarship, constitutional law? Are you an originalist?
I am an originalist in the sense of an historian, but not as a lawyer. What a political historian tries to do is understand how the people of a particular time understood their problems in light of their conceptual apparatus and in light of the alternatives they faced. We ask what questions were they asking and what answers they provide. Contemporary legal originalists start with our questions, many of which would not have occurred to the framers. And they say, well, if the framers had our problems and our way of thinking about things, how would they resolve those problems, which to a political historian makes no sense.
A review of your book, A New Introduction to American Constitutionalism, in the Tulsa Law Review, said you have no horse in the originalism race, but rather you argue persuasively that the debate between originalists and their critics has reached a point of diminishing returns, that you urge constitutional theorists to move beyond the study of interpretive methods and judicial review to consider other, arguably more fundamental sources of constitutional legitimacy, including social norms and constitutional politics, as you were just saying. The interplay of political institutions that are set in motion by constitutional texts, but which often evolve in directions not anticipated by their designers.
No, that's about right. To add what I said, imagine, as even most originalists agree, the Supreme Court hasn't got the original understanding of the Constitution right for 235 years, nor have they gotten the Constitution right for 235 years by any other theory of constitutional interpretation. This might suggest to a social scientist that the Supreme Court is not well structured to follow interpretive fads in the law schools, whether they be conservative, liberal, or whatever. We might think first of what job does the Supreme Court actually do, and then ask, well, is this a good job for the court to do? And if not, how might we reform the court so it would do a better job?
You know, I have no legal background. I'm a journalist with an interest in history. I've done a good deal of historical reading, but, legal texts go over my head. I often find some of the hair splitting that is involved to be rather confusing, even flying in the face of common sense sometimes. We'll get to that in a moment when it comes to the Colorado Trump ballot case. I just want to share one more thing with you about originalism, because that is at the heart of what we're discussing here today. Sean Wilentz just described originalism in his recent essay in the New York Review of Books. Textualism and originalism, he says, the doctrines on which conservatives have long based their judicial philosophy, are nothing but instruments of right-wing activism to produce prearranged outcomes. Do you agree with that?
I would modify this in an important sense. I have friends in the academy that purport to use originalism. I'm not sure they do, and they're all over the place ideologically. So when academics use originalism, many of them are trying to get at the history. But it is remarkable that for too many judges on the court, when they use originalism, it is as if Ronald Reagan and Donald Trump were framers of the Constitution. 18th century Americans don't map neatly onto our ideological divide. They don't map neatly onto our ideological divide in 1866 either. We would not expect an originalist court, to the extent originalism is possible, to be on one side all the time of our constitutional and political debates.
And of course, we know the Federalists in the 1790s and the Jeffersonians, on the other hand, they had competing views of what the original meaning of the Constitution was. And the ink was still drying in those days. So I just find the concept of originalism to be a fantasy.
One might say when originalism works well, it's not needed. So, for example, we might agree every state gets 2 senators. I take it there is no great dispute over the meaning of the word "two" and over the meaning of the word "senators." But precisely because originalism works so well, there's no dispute for originalism to resolve. It's precisely when there's been some change or there was some underlying dispute that we need a method of constitutional interpretation. And then, as for reasons you pointed out, originalism doesn't work so well.
Well, I thought the terms officer of the United States and office under the United States were pretty clear, but what do I know? So, big picture here, what did the Supreme Court, in your view, get wrong in its unanimous decision, which was kind of broken up then into 3 separate opinions? What did it get wrong in the Trump ballot case?
I should add, blessedly, they didn't go into who was an officer of the United States and an officer under the United States. And I'll start with, in many ways, what is wrong with the decision is what is wrong with the pattern of Supreme Court decisions. So suppose the justices had said in previous cases, we're pragmatists. We give some weight to text and history, but mostly we ask what policy makes sense for 21st century America. If that was what they were doing, a reasonable argument could be made that the best policy is a national election should be run by Congress. No state should be allowed to unilaterally disqualify a candidate for the presidency. But there are three problems with that. First, the Supreme Court has consistently said states can run federal elections unless Congress says otherwise. Why was that rule discarded in this case, but not discarded in other cases that serve conservative interests? Second, the Supreme Court has said in cases like abortion, we go by the original understanding in 1866. The original understanding in 1866 was clearly that, in fact, states could disqualify unless Congress said otherwise. Why did the original understanding matter in abortion cases, but not this case? There is nothing in the text of the Constitution that says the rule for disqualifying state candidates is different from the rule for disqualified federal candidates. Supreme Court in gun rights cases said, we look at the text and we look at the text hard. Why was the text not looked at in the same way in these cases? So the problem really is consistency with what the Supreme Court has been saying. A different Supreme Court might have justifiably reached similar conclusions to this Supreme Court.
My amateur view here is that the court took the path of least resistance, that if it had sanctioned Colorado's move, they were worried, and I think some of the justices stated this view during the oral arguments, it could cause a chaotic situation between now and November.
The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States.
But it's puzzling. They said it could be chaotic. Well, here's what we know. We know that states are allowed to have different methods of voting. As we saw in the Bush versus Gore, Florida had one method of voting no other state used, caused a lot of problems. States have different rules for how candidates can get on the ballot. It's quite possible Robert Kennedy Jr. will be on the ballot in some states and not in others. The fear of chaos is part of our system. States have different rules for elections. Can you have mail-in ballots? Can you have absentee ballots? What are the times for voting? Do we have electronic ballots? Do we have paper ballots? States have different rules for getting on the ballot. Abraham Lincoln was not on the ballot in many states in 1860. So the question is, why was diversity now such a big deal when we normally tolerate and celebrate diversity in federal elections? Now, maybe it's a lousy idea, but it's not a lousy idea with respect to Section 3, but not with respect to everything else.
Let's go to an issue that was not taken up during the oral arguments in any amount of detail or any definitive conclusion. They didn't get to what I thought, most important issue of all, whether Donald Trump is an insurrectionist. You have said he is, and you have come up with a definition for what insurrection is. Why is Trump an insurrectionist? Professor Graber, give us your definition. And where did the court go wrong in not dealing with that issue?
I should emphasize first, what I'm about to say is not my definition. What I did was I looked at every federal and state case that mentioned insurrection from the American Revolution to the end of Reconstruction. I looked at every legal treatise that discussed insurrection, and it turned out, outside of the usual academic, problems at the margin, everybody before 1866 had the same definition. An insurrection has 4 elements. First, you need an assemblage. All that is a group of people, and everybody agrees. On January 6, 2021, there was a group of people. Second, the group of people has to be resisting the implementation of federal law. Everybody here agrees. The group of people on January 6, 2021 were resisting the federal laws, both constitutional and statutory, that enable the peaceful transfer of presidential power. The resistance, third, has to be by force, violence, or intimidation. If you are having a protest saying, we don't like what you're doing, we're going to vote against you, that's not an insurrection. You have to try to prevent the implementation of a law by force, violence, or resistance. Well, maybe trespass isn't, but we saw threats to murder members of Congress and the vice president. We saw, physical invasion of the Capitol. Members of Congress fled for their lives. That is force, violence, and resistance, and nobody denies that. Finally, it has to have a public purpose. Public purpose has 2 elements. First, it can't be spontaneous. It can't be that, people just got so mad that they wound up throwing a rock, not even thinking about it, and regretting it later. Second, the purpose must be public, not individual. If the mob was there to sell furniture on eBay, we want to get congressional furniture, get a Nancy Pelosi autographed pen, sell it on eBay, that's a private purpose. But we know there were militia groups that were planning violence. They came armed. We know they had a public purpose. So, by 1866 definitions, the definitions originalists tell us we're supposed to be using, this was an insurrection, and I suspect the reason the majority didn't go there is they knew that it was an insurrection, that when the concurring opinion called Trump an oath-breaking insurrectionist, nothing in the main opinion sought to refute that.
And Trump's attorney during the oral arguments, Jonathan Mitchell, he did actually have an exchange with one of the justices about this, where he says it wasn't an insurrection, it was a riot.
The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6 qualified as an insurrection, as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an insurrection? What is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so
riot
the point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson.
So you went all the way back to Edward III, 14th century legal treatises to come up with this definition. Or, as you said, you didn't just come up with this. This is the definition of insurrection. Could the Supreme Court have made a ruling along these lines? Could it have said, yes, Trump is an insurrectionist, or would they have, say, deferred to the court system? Because I'm not sure that Donald Trump's even been charged with insurrection.
Well, there's no requirement that a person be charged with insurrection. Let's go back to 1866.
Under Section 3 you're talking about.
Yeah, under Section 3.
Yeah.
Everybody knew that there were not going to be massive treason prosecutions throughout the land. In fact, everybody knew President Johnson was unlikely to bring any treason prosecutions except perhaps against Jefferson Davis. So there is no requirement of a treason prosecution. And one of the reasons is penalty for treason historically is death. Congress was aware that's often too strong. We don't want to execute everybody in the Confederate Army or even everybody in the Confederate government. We don't want to execute everybody who took part in January 6th. Most of them we don't even want to give long terms of imprisonment. But if you are a person who violently resists federal law, you shouldn't hold office in a constitutional democracy. That's the logic.
So this brings us to the issue of self-execution, and I'm not referring to a person executing themselves, talking about the sections of the 14th Amendment. During the Civil War, after the Civil War, there was no question that they were dealing with people who had committed insurrection. Today, this is disputed. So I've been calling January 6th a riot the whole time, but my recent reading has me leaning more toward what you have said here, that this was or could be considered an insurrection. But it does bring us, I am getting to my point here, Professor Graber, to the issue of whether Section 3 is self-executing, because if Trump is in fact an insurrectionist, then that's it. He's disqualified. Period. End of story. And during the hearing, the attorney for Trump, Jonathan Mitchell, and Justice Sonia Sotomayor got into an exchange over this where she said, you're telling us that self-execution is not what it's always meant.
You want us to say that self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. Mm-hmm. And so this is a complete preemption in a way that's very rare, isn't it?
What did you make of their exchange, and what can you tell us about the Trump team's, the legal team's argument that for some reason Section 3 is not self-executing, but all the other sections are?
It's a funny kind of argument, and in many ways, given my own position, it's probably better to have someone who believes in the argument. And in some ways, if you want to say, what's the argument that Santa Claus exists, you probably should talk to a 7-year-old and not their parents, because the 7-year-old will give you an argument at least that the 7-year-old is convinced of. The idea is that, in fact, you need congressional legislation to implement Section 3. Now, if we think about that, there's an interesting problem. When the 13th Amendment was ratified, there was no congressional legislation. Does that mean everybody who was a slave when the 13th Amendment was merely being considered remained a slave? That slavery did not end when the 13th Amendment was ratified, and Congress could return the United States to a state of slavery by simply repealing all legislation forbidding slavery. So we're inclined to think that no provision of the 13th, 14th, and 15th Amendment requires congressional legislation, that congressional legislation can assist. There may be one exception that's important to understand, Section 2. Section 2 talks about apportioning representatives to Congress. And we agree wholeheartedly that states can't execute that because states have no say in the apportionment process. But, as I pointed out, for better or worse, and many of us think for worse, states have a major say in running elections. Article 1 of the Constitution says states essentially run federal elections. So if we have a provision dealing with the qualifications of a candidate in a federal election, states can implement it.
Jefferson Davis understood he was automatically disqualified under Section 3 of the 14th Amendment. Donald Trump disagrees, so we did need somebody to make a decision here because the Colorado case was challenged and it was taken up by the Supreme Court. And now the Supreme Court has ruled that when it comes to federal offices or federal candidates, especially the president, it is up to Congress to disqualify. But I think the framers of the 14th Amendment, maybe you agree with this, made it pretty clear that they didn't want it to be left to future Congresses, which are partisan political bodies, to decide who can serve and who can't when it comes to insurrection. They wanted a permanent ban placed in the Constitution that is, again, self-executing. It's automatic. Because if you leave it to politicians, if you have enough sympathizers with the insurrectionists in Congress, well, then they would let them return to office. See what I'm saying?
I think actually the framers of the 14th Amendment, with important caveats, were more sympathetic to Congress than we are. They believed if the United States held fair elections with one person, one vote in their own version of it, Republicans would control Congress, African Americans would have substantial say in Southern politics, and Republicans in Congress and an African American coalition in the states could be trusted to implement Section 3 fairly. They were probably more mistrustful of courts. After all, courts had decided Dred Scott. Chief Justice Taney, before he died, was known to be an enemy of Union policy during the Civil War. So they were willing to trust states, to trust politics. They actually distrusted judges who they saw as very partisan. Now, in our polity, we see lots of people as partisan, and in some ways, we have to trust the people we elect with judicial check. So it's a fair question to ask. When someone disqualifies Donald Trump, have they done so on a reasonable interpretation of the law? Courts are good for that, but courts should share power with others.
But it's not up to Congress to pass another layer or a piece of legislation to disqualify someone, right? And that's the whole point of self-execute.
Now it is.
Well, now it is.
But that's not what the framers thought otherwise. Once the 14th Amendment was ratified, the Union Army started telling people, guess what? You're not running for Congress. Guess what? You're not in the state legislature. Sorry. Former rebels petitioned Congress for exemptions. Why would they do that if there was no legislation?
So another issue that came up historically during the oral arguments was, why have there been so few of these cases since the Civil War over the past 150 some odd years? Well, there was an Amnesty Act of 1872, right? What did you make of that exchange among the justices and the attorneys? It seems that they didn't understand why there have been so few cases of state officials disqualifying federal office seekers.
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been – states certainly wouldn't have the authority to remove a sitting federal officer. So what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples? Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is, do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then.
Well, I mean, there are a great many reasons. One of them is we haven't had, since the Civil War, a lot of insurrections that public officials have participated in. So the better question is not how many prosecutions have there been, but how many disqualifications could there have been? So let's take the early period. Nobody could have been disqualified in 1866 because, in fact, Congress was not allowing representation from the southern states. When Congress finally allowed representation, African Americans could vote. The Republican Party dominated. Mississippi, for example, sent 2 African Americans to the Senate. They're not subject to Section 3. Democrats and former rebels come to the Senate and Congress only after the Amnesty Act of 1872. And then as we look through history, what other president at some point participated with an assemblage to resist by force federal law? So it's a bit like saying, we can't find somebody guilty for, say, dropping a bomb that destroys the Congress because we've never found anyone guilty of that before. It's never happened before. Thomas could not name one candidate who was elected who could have been disqualified.
No one brought up the amnesty of 1872, not one.
But even before 1872, there was simply no occasion for disqualifying a significant black majority representation, not majority, but black and Republican representation from the South. Those weren't the Confederates. Confederates get back in largely only after the Amnesty Act, which, as you point out, wasn't raised.
Well, I want to say that I'm still torn over all of this, how to think about the Supreme Court ruling and its implications for the Constitution. But as a historical matter, I found the oral arguments to be less than inspiring, I'll put it that way, or just downright confusing at times, to borrow a turn of phrase from the headline of Sean Willentz's most recent essay in the New York Review of Books. It was "The Constitution Turned Upside Down, Case in point, all the discussion over whether the president is covered under Section 3 of the 14th Amendment, as if you could read the Constitution in a way to exclude the most important office of them all when it comes to keeping insurrectionists out of power.
Justice Sotomayor?
I just want to pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
So where did the idea come from that the president is not covered under Section 3?
It comes from England, because the king is historically not an officer of England or an officer of the crown. King gets his authority from God. Everybody else gets their authority from the king. One of the differences in the American presidential system is that, in fact, everybody, including the president, gets their authority from the law. So everybody, the president, the vice president, the chief dog catcher, is an officer of the law and under the law. Now, there were still older ways of phrasing things. So even though it's very clear, the framers thought the president was an officer of the law, there are provisions in the Constitution that says the president shall commission the officers of the law. The president doesn't commission the president. Now, when the framers were confronted with this, they said, you know what? Guess what? Hot in Philadelphia. We didn't always use the words precisely. The president is an officer of the law, except for when the Constitution makes clear otherwise. I have examined all the usages of officer of the law and officer under the law by the 39th Congress. They frequently refer to the president as both. They never deny the president is one. And in fact, in a report dealing with Congress, they again repeat, Constitution isn't entirely consistent. We assume the Constitution means what any normal person on the street or a fancy journalist like yourself, what they would mean. What they would mean by that, we don't normally presume the Constitution contains technical language unless it's clear it does.
Officer of the United States, an office under the United States. I mean, this was ridiculous. And I think it was Justice Kagan who brought up the absurdity of all this.
And is there any better reason, if you go to the office argument that Justice Jackson was suggesting, is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's an even tougher argument for us to make as a policy matter, because one would think of all offices, the presidency would be the one you'd want to keep out the Confederate insurrectionists. That's the commander-in-chief of the Army. So, again, that's why we're leaning more on the officer of argument than the office under. We're not conceding office under, but we definitely have the stronger textual case and structural case on officer of the United States.
You can be the federal dog catcher, but not the president.
You know, and the historians in the amicus briefs, these great historians, authorities on the Civil War and Reconstruction period who wrote these briefs for the court, they show plenty of evidence that at the time people understood this to mean the president because of the Jefferson Davis issue. It was understood that he would run for president again if he was given amnesty, and Davis himself understood that he had been automatically disqualified from holding office again. I mean, he was an office holder before he became a traitor. One other thing here. Oh, the Griffin case. Sotomayor asked Jonathan Mitchell about this. She said, are you basically saying that because of this Griffin case, state election officials can't bar or disqualify state candidates, federal candidates, and the president, all three? And he said yes, if you agree with the Griffin case.
Can states enforce the insurrection clause against their own office holders, or can they enforce it against federal officials, or can they enforce it against the president? Those are all three different questions in my mind.
And the answer to all three of those questions turns on whether this court agrees with the holding of Griffin's case. If Griffin's case is the proper enunciation of the law, then a state cannot do any of the things Your Honor suggested unless Congress gives it authority to do so.
So a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as presidential.
What's the Griffin case, and why is it not important, despite what some people say?
The Griffin case is important. It cuts against my argument. Inevitably, arguments aren't 100% airtight. But in Griffin, we had a state judge in by the way, a very racist proceeding, sentenced an African-American man, I believe to death or something, to prison on very dubious grounds. And the lawyer responded, this sentence is invalid because you are a former office holder who joined the Confederacy. And Chase said, nope, you cannot disqualify someone in the absence of legislation. And there wasn't any legislation. Now, what's rather interesting is the year previous, he had said, with respect to Jefferson Davis, Section 3 was self-enforcing because that got him the result he wanted in the Davis trial. In other words, Chase is one of the leading authorities on both sides of the self-execution debate. When Congress legislated on Section 3, members of Congress did not say we have to do this because states are incompetent. They do not have the power to legislate. They rather said we don't like what's going on in the states. They're not doing it well. We need to step in.
We'll wrap up with one of my big concerns here is that we know from history what happens when former insurrectionists return to office. They were amnestied in 1872. There was another amnesty in 1898. And that is, the former Confederates reimposed white supremacy, undid all the progress that was supposed to take place after the Civil War.
The 1870s begin one of the most racist periods in American history, and it begins in part because the former Confederacy rises again, but this time achieves their goals quasi-legally, with the help of a lot of illegal Klan violence that goes unpunished.
I guess what I'm trying to say is if it's up to Congress from here on out, you can expect pretty much no one is going to be disqualified.
Unless we're in a period where nobody is threatened or disqualified and Congress actually says, you know, we ought to have a law on the books for this for the future. But in this Congress, and it's unfortunate that law-breaking is tolerated if it's on your side of the fence.
All I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state, and flipping the state is a great testament to our country.
There's no way we lost Georgia. There's no way. That was a rigged election.
Now we gather due to a selfish man's injured pride and the outrage of supporters who he has deliberately misinformed for the past 2 months and stirred to action this very morning. What happened here today was an insurrection incited by the President of the United States. Those who choose to continue to support his dangerous gambit by objecting to the results of a legitimate democratic election will forever be seen as being complicit in an unprecedented attack against our democracy.
On the next episode of History as It Happens, he is the longest-serving prime minister in Israel's history. Now Benjamin Netanyahu is waging a war for his political survival. We'll look at his career next as we report History as It Happens, a podcast from the Washington Times. I'm Martin DeCaro.